So privity of contract, yeah. Privity of contract is a personality principle of the contract, yeah. We understand that when there is an agreement, we previously talked about subjective principle, subjective requirements of an agreement. There is also an objective requirements of an agreement. When we talk about subjective requirements, we refer to the parties, parties making the agreement. So that's why it's subjective, because it's related to the persons, And when parties or persons are making an agreement, the benefits and also the burdens, artinya, which means that the rights and obligations, because we also talk about the law of obligations, hukum perikatan. So the perikatan is the obligations, is the burden, where one party will have to do something for the benefit of the other party, or we can also say for the right of the other party, So because one has the obligation and the other has the right to receive something. So that has to be between the parties involved. This is an important principle under the contract law. You cannot make a burden you cannot put an obligation or burden to the parties outside the agreement. You cannot do that, In contrast, you cannot also give rights to the party outside the agreement. But there are exceptions, That's what we learned today. These are the principle of the contract law, which means the privity of contract that binds the parties in the agreement. But there are some exceptions. The exceptions are unique. I think we don't do it all the time. We normally don't do it, but there is an exception. And it will make the privity of contract looks weak because of it, But I think the principle is still the same. Even though there are exceptions, it doesn't mean that the privity of contract will be considered as a weak principle. Because as we learned before also, that when we talk about defective will, cacat kehendak, when we refer to the the consent by the parties, and if there are some defective wills like coercion, error, or fraud, we will analyze those defective wills also based on the privity of contract, For example, if there is a party to the agreement doing some fraud, there is a defective will on the consent of the parties, right? But who is doing the fraud? Will it be the other party or one of the parties, or the parties doing the fraud can be considered as the party in the contract plus the third party outside the contract, or even the party doing the person doing the fraud is really the third party. It's not the person in the agreement itself, So based on the privity of contract, we cannot say that the party doing the fraud is the person or the party outside the contract because of this principle, The privity of contract is the personality principle, which means that the rights and obligation between the parties are binding the related parties to the agreement. It does not bind the other parties outside the agreement. That's the principle. So if there is a coercion, if there is a abuse of conduct, if there is a fraud, it will be related to the parties involved, yeah, in the agreement. It cannot be referring to the third party outside the agreement, because it will be breaching the privity of contract principle. How can we declare that the third party outside the agreement is doing the fraud, affecting or influencing the current agreement that I have with the other party? It doesn't make any sense, yeah, because the third party doesn't have any rights or obligations, or perhaps any interest, yeah, with the agreement that A and B has made, for example. But there is an exception on that, yeah. So that's why that's what we are going to learn today. So let's move to the 1315 of ICC, yeah. You should open your Indonesian Civil Code, yeah, and you look into it. It's confusing at the first sight. I think when I was a student and even after I work, I read again the 1315, yeah, and I'm confused what is the real meaning of this clause, ya. Pada umumnya, tak seorang dapat mengikatkan diri atas nama sendiri atau meminta ditetapkannya suatu janji daripada untuk dirinya sendiri. Ya. Pada umumnya, tak seorang dapat mengikatkan diri atas nama sendiri atau meminta ditetapkannya suatu janji daripada untuk dirinya sendiri. Yeah. So in principle, yeah, when you look into this, it will mean that when you enter into an agreement, yeah, you will represent yourself, yeah. An individual can commit only himself or agree to something on his own behalf, yeah. Of course, you cannot enter into an agreement using other party's name, yeah. Of course, except you obtain a proxy or power of attorney, yeah. But that's difference, yeah, because when you obtain a proxy or power of attorney, that means a surat kuasa, yeah. You obtain surat kuasa from the other party. You will be the proxy of this guy, right? The authorizer. Legally speaking, the one who will be bound with the agreement that you made, legally speaking, will be your pemberi kuasa, your authorizer, than you as penerima kuasa, because you as penerima kuasa or the authorized person will act on and will act for and on behalf of the authorizer. Without that, you cannot act on behalf of the other party. So this also refers to each person. When each person enters into an agreement, they will act for themselves. Yeah? They cannot refer to the other party. They cannot put burdens, obligations, or giving benefits or rights to parties outside the agreement. Yeah? Let's say that there is an A and B. Yeah? A and B enters into an agreement. What has been agreed between A and B cannot give obligations or cannot put obligations or any rights or benefits to C, for example. Yeah. So A and B has rights and obligations, and they have to do it between themselves. Yeah. They cannot put burdens, obligations, or giving benefits or rights to the party outside their agreement. And in this example is C, yeah, because A and B has the agreement and C is the third party. So you will you will also hear about the third party. Ya, the third party itu pihak ketiga. Ya. In the agreement, you will always hear this phrase, ya, third party, pihak ketiga, which means that any party outside the agreements, ya. So if you perhaps there will be some clauses, some provisions in the agreement that you will draft someday, that the parties are prohibited to inform or to disclose the information within this agreement to the third party, without the written consent by the other party. So third party will refer to any party, outside the agreement is made. So referring to the personality principle, this third party is C. So when A and B enters into an agreement, any third party is not related to it. Whether it is C, D, E, F, G, or whatever it is, they are not related. They cannot interfere. They cannot get benefits. They cannot get obligations or burdens. Except on the certain circumstance. So binding aimed at carrying out obligations or undertaken to do something while asking for a promise is aimed at acquiring right to something or being able to demand something. So an agreement lays only the rights and obligations between the party who make it. Okay. The other people are third parties who have nothing to do with the agreement. If you are going to bind someone else, there must be a power given by that person. This power referring to the power of attorney, proxy. When I say power of attorney or proxy, it will mean as kuasa, pemberian kuasa. But again, it doesn't mean that when you have a proxy, you can bind someone else, because it doesn't mean like that, right? If you are obtaining a power of attorney on behalf of your father, for example, right? And then you enter into an agreement with B, So you are A and B is the other party. And as A, you have proxy from your father, right? So you are proxy of your father, and then you enter an agreement with B, and then after it is entered, after it is executed, the agreement, who is legally bound on that agreement? Is it your father and B, or is it you and B, right? We are sometimes confused with this concept, but legally speaking, of course, you are not bound to the agreement, because what you did is just to act for and on behalf of your father. So your father will be legally bound to B, even though your father doesn't sign the agreement with B. You sign it on behalf of him, right? So that's what will be implemented. So the personality principle, even though there is a proxy, it's still binding the parties that are legally bound. So if you are a proxy, if you are a proxy holder or authorized, and you are acting on behalf of the authorizer will be legally bound, not you as the proxy holder. So that is the 1315. We are jumping to 1317, but we are going back again after that to 1316. So 1317 is another interesting clause. In my view, it's very hard to understand. but it's the concept is deep actually. Yeah, the concept is deep, and this is the starting point of an exception of 1315 actually. This is the starting point of an exception on 1315. We call it as Durden bedding in here. It's not a third party agreement. The translation is not really correct actually. Tapi bisa dibilang perjanjian untuk kepentingan pihak ketiga ya. So agreement for the benefit of third party. Yeah. In short, I write this as third party agreement, but actually it is an agreement for the benefit of third party. So the 1317 lagi pun diperbolehkan juga untuk meminta ditetapkannya suatu janji ya, guna kepentingan seorang pihak ketiga. See, the third party is evident now in here, yeah, in this 1317. Well, it's weird, right? Because the agreement only involved two parties, yeah, one and B, A and B. So the first party and the second party, yeah. But this specifically speaks about the third party. Apabila suatu penetapan janji yang dibuat oleh seorang untuk dirinya sendiri, atau suatu pemberian yang dilakukannya kepada seorang lain, ya, membuat suatu janji yang seperti itu. Lagipun diperbolehkan juga untuk meminta ditetapkannya suatu janji guna kepentingan seorang pihak ketiga. So the right for the benefit of the third party, ya, suatu janji, you can say that this means that a promise for the third party means that I want to give a certain right to the third party or a certain benefit to the third party. Apabila suatu penetapan janji yang dibuat oleh seorang untuk dirinya sendiri memuat suatu janji seperti itu, ya kan? So this is an alternative ya, yang dibuat oleh seorang untuk dirinya sendiri, atau suatu pemberian yang dilakukannya kepada seorang lain memuat suatu janji yang seperti itu. Siapa yang telah memperjanjikan sesuatu seperti itu tidak boleh menariknya kembali apabila pihak ketiga tersebut telah menyatakan hendak mempergunakannya. So if I make such a promise and the third party is aware of it, yeah, that I make such promise to this third party for the benefit of this third party. So this third party is aware of it, that he gets some benefits due to my promise, and he intends to use it, then I cannot withdraw it, because it's some sort of like an offer and acceptance, right? We learned last session or a few last session before about offer and acceptance, and if an offer is accepted, it will be binding the parties, right? So this also refers the same, yeah. When I offer the third party the benefits, some benefits to this third party, and the third party is aware of my offer, yeah, and then accept it because he would like to use it, then this will be binding. Yeah? I cannot just withdraw it voluntarily or unilaterally, because that will be a breach of contract. Yeah? Because when an offer and acceptance meets, there will be meetings of mind. There will be consent to the parties, right? And if the objective principles are fine, I mean the objective requirements of the agreement are fine, no breach of law and everything, so of course the agreement is valid. Yeah, the offer and acceptance is accepted, the agreement is born, it is valid and can be executed. So this is the agreement for the benefit of the third party. Now this is the example, yeah. A make an agreement with B. In that agreement, he requested the promise of rights for C without the power of this C. Yeah. So in this case, when A makes a promise for the benefit of C, A is not the proxy. Yeah, A doesn't have any proxy from C. because he does not bind C actually. Yeah, this is not a proxy relationship. Yeah, this is C is third party. Yeah, the agreement is between A and B, but A put a burden to B. If I make an agreement with you, there should be some benefits for C. Yeah. So in this relationship, A is called a stipulator, which means that this is my condition. Yeah. If you want to agree with me, this is my condition. Yeah. I stipulate the condition. And B is called a promiser. Yeah. Because B in return gives promise to A that I will do what you requested me to do for the benefit of C, right? So that's why B is called as promiser, but A, as the one who determines the conditions of an agreement, is called as stipulator. Well, this is just a what is it? A defined term to make it easier for us to understand. Yeah, but let us move forward so you can understand better this concept. I believe it is not easy to digest in the beginning. And so an individual who has concluded an agreement cannot revoke such if this third party has declared his intent to exercise it. Yeah, this is the offer acceptance we talked about before. Whoever has promised such a thing may not retract it if the third party, yes, this is the same understanding. Usually a third party agreement described as an offer made by the party. Okay, this is okay, also fine. Example, C sells the car to D with the agreement that for 1 month, the car can be used by B. Yeah. C sells car to D with the agreement that for 1 month, the car can be used by B. So you can see that the parties of the agreement are C and D. Yeah, B is outside the agreement. Yeah, B is not the party. So B is considered as third party, right? There is the first party, there is the second party. Let's say that C is the first party, D is the second party. These are the parties to the agreement. B is outside, yeah. B doesn't even know perhaps that C and D has an agreement. But of course, this is the request of C, because C is the stipulator and D is the promiser. C sells the car to D with a condition, right? With the agreement that for 1 month, the car can be used by B. So it means that C cares for B, right? C would like to take care B, yeah? But in another way around, C also wants to sell the car to D, right? So he's selling the car to D, but he puts on condition to D, right? Not to B, to D. Saying that D, Delta, I'm selling the car to you, but you have to give something to B. Yeah, you have to give for 1 month that B can use the car. Well, it can be for whatever reason, right? Perhaps B would like to go abroad, out of town, perhaps, and that's why B needs a car. Or B is still finishing his study in the university, so he's needing his car, for example. I don't know. So it can be in many things, right? So that's why this is actually the 1317. If you look into the 1317, ya, apabila suatu penetapan janji yang dibuat, jadi kan 1317 says lagi pun diperbolehkan juga untuk meminta ditetapkannya suatu janji guna kepentingan seorang pihak ketiga. Meminta ditetapkannya suatu janji, ya. So it means that I the other party to promise to me for the benefit of the third party, right? Meminta ditetapkannya suatu janji guna kepentingan pihak ketiga. Apabila suatu penetapan janji, ya, if promise yang dibuat oleh seorang untuk dirinya sendiri, artinya for me kan, for my benefit. For my benefit referring to C, right? In this case, C. For the benefit of C, because when C sells the car to D, C gets the benefit of it, right? But C also cares about the third party. In this case is B. So that's why meminta ditetapkan suatu janji ya. So C sells the car to D, but C says to D, I'm selling this car to you, but you have to give something to B. Yeah. What is that something? You have to allow B using that car for 1 month. Right? So this is the first alternative yang dibuat oleh seorang untuk dirinya sendiri. Memuat suatu janji yang seperti itu. And then the second example, we see that one gives capital for free to others to use to trade, with the agreement that this person will finance a student school. Now, when you give your capital or you give some amount of money for free, it will be considered as hibah, kan? Hibah, right? The legal term is hibah, ya. We can say hadiah, ya. We can say hibah, gift or everything. But hadiah kan hibah, ya. With the agreement that this person will finance. So A gives capital for free to others. Let's say that this is A gives something to B, right? A gives capital to B. So B can use it for commerce. But when A gives this capital, this amount of money to B, A said to B that the condition of my granting will be that you take care of this student, right? So that will be the second alternative in 1317, atau suatu pemberian yang dilakukannya kepada seorang lain, ya. So, lagi pun diperbolehkan juga untuk meminta ditetapkannya suatu janji guna kepentingan pihak ketiga. Apabila suatu penetapan janji, the first one said yang dibuat oleh seorang untuk dirinya sendiri. Ya, this is the first example. But the second alternative, apabila suatu penetapan janji yang apabila suatu penetapan janji, nah ini dibacanya kan, melalui suatu pemberian yang dilakukannya kepada seorang lain, ya. Ini terjemahan saya mungkin kurang bagus ini. Tapi prinsipnya the second alternative kan talks about pemberian yang dilakukannya kepada seorang lainnya. Suatu pemberian yang dilakukannya kepada seorang lain. So this is the second example when one party gives money to the other party with condition, with the promise that that other party having that money will finance student schools. Yeah. So there are other examples. If you see into the J.Satrio's book, of course, like I said before, it's even clearer. Yeah, it's even clearer because J.Satrio combines his explanation with legal case also, with legal case study. So it will make it easier, clearer to understand how to look into 1317 actually. Janji untuk pihak ketiga, ya. So J.Satrio also mentions about several conditions in here, ya. Yeah, these examples. A sells his house to B on condition that C can continue renting the house from B. Yeah. So A sells house to B on condition that C can continue. C is the third party, right? C can continue rent out the B's house. right? Or A, this one is the first example is A is selling the house, yeah, so it's not free, it's not giving something, right? But the second example, A grants or gives, yeah, his motorcycle to B on condition that B gives his bike to C, yeah. So A grants or gives motor to B on condition that B gives his bike to C. So this is the agreement for the benefit of third party, yeah, because the parties to the agreement is not C, right? It's between A and B actually. But because of this agreement, because of the agreement between A and B, C gets the benefit. C gets the benefit of it, right? Because C gets something out of the agreement between A and B, yeah. So of course it will be very nice for C, yeah. Not very nice to A and B perhaps, yeah, but as C, it will be very nice for C. And this actually the 1317. I don't know whether you heard about the trust concept, yeah. Trust concept under common law system, yeah. We don't have trust law actually, but some transactions, some securities, some capital market transactions are in the form of trust, yeah, or we can say it is trust-like arrangement, yeah. Where when we talk about trust, there will be a beneficial owner, yeah, there will be a legal owner, and there will be a manager, yeah, the person managing the property, yeah. And in here in Indonesia, we don't have the concept of beneficial owner actually. We don't have it, but the one regulation for establishment of limited liability company was enacted, yeah, some time ago. I think 3 years ago, 4 years ago, declaring that each person having established a limited liability company will have to declare who is the beneficial owner of this company. So perhaps, of course, in capital market regulations, there is also a term of beneficial owner, yeah. So even though we don't really have that concept, it's everywhere also in our regulations. Let's say that if you have a real estate or if you have a land in Indonesia and the name written in the certificate is under your name, yeah, so you will be considered as the legal owner and beneficial owner, yeah, because we don't recognize beneficial owner of land. But in common law system and in trust arrangement, if it is written that your name is the legal owner of the land, there might be a beneficial owner of the land. Yeah, perhaps the legal owner is your name, but the beneficial owner is owned by someone else. Yeah, so there is a beneficial owner, there is a legal owner. So it's a separation of ownership in the common law system based on trust. Yeah, we don't have it in here. Well, not entirely don't have it. Yeah, of course we recognize and we adapt some concepts, but essentially we don't have it. And referring to the 1317, actually there is some kind of resemblance, yeah, or similarity what I said before about the beneficial owner and legal owner with the 1317 actually, yeah, because the 1317 is an agreement between two parties that gives the benefit for the third party, right? So the third party can be considered also as the beneficial owner in some perspective, yeah. Because the agreement between A and B is made, but giving also the benefit for the third party, yeah. I don't know whether you have learned the agrarian law, land law in President University, but if you have learned that, you should be aware that we can have a HGB over hak milik, right? We can have a hak guna bangunan over hak milik. So in terms of this 1317, yeah, if we look into the land law system, or even if it is related to the foreigner, yeah, because we always have problems about the foreigner ownership in Indonesia, that a foreigner can only have right of use, right? But perhaps nobody will want to um, give right of use to the foreigner. So let's say that there is an Indonesian holding a hak milik, right? So the owner of land holding a hak milik, and then there is a foreigner, right? The foreigner will need, or we can say like this, yeah. So A is the landlord, is the owner of the land of hak milik, A, and B, perhaps let's say that it is A's son, yeah. So B is A's son, the son of A, yeah. And C is the foreigner, yeah, foreigner that would like to have a house for a certain period in Indonesia. So if we look into the 1317, the agreement for the benefit of the third party, we can see that A might give his land to B, his own son, right? So by grants, by hibah, yeah, with condition to B that B would have to issue or agree the issuance of hak pakai over hak milik and give the benefit of 30 years, for example, to this foreigner to live at the land. So this is the 1317 clause, yeah. The agreement for the benefit of the third party. The third party in this regard is the foreigner, yeah. So A gives land to B on condition that B will give hak pakai over hak milik and give it to the foreigner, yeah. So you can see that the foreigner will be the legal owner of hak pakai, yeah, but the B will still be the legal owner of hak milik, right? So there are two legal owners over the same land, but of course, since hak pakai is over HM and hak pakai will be issued perhaps 25 years to 30 years, so the foreigner will have the right to use the land for 25-30 years, and the B as owner of land will have to wait for it, yeah. So this is one of the examples also for the application of 1317 that is similar to trust-like arrangement. So it is as if that the beneficial owner actually is B, right? Because B still have the hak milik, right? But the legal owner, temporary legal owner, is the foreigner, C, right? So there is a legal owner, there is a beneficial owner, even though B is also considered under the legal system of Indonesia as legal owner, yeah. But it will appear to be like that because B in temporary cannot use his land, because he gives it to C. And the application of 1317 with that regard, with that perspective, may be considered as trust-like system. So it is interesting actually. I wrote an article and published in the Asia Pacific Trust Law, I think. It is published in that book. So it is written by various academicians from various countries, like in Asia Pacific. So it's like Japan, Hong Kong, Taiwan, and Australia, Vietnam, even Thailand, Indonesia. I wrote for Indonesia section. So, that's where I learned about the 1317, and I learned more about the trust system, and we don't have it. And the other thing that is very similar to trust in Indonesia is the wakaf actually. Wakaf is very similar to trust. And when I spoke there, when I presented my article in the University of Melbourne at the time, they are interested in discussing about wakaf actually, and they mentioned that wakaf is considered as the origin of trust system actually, they said. So it's the origin. Some say that the origin of trust system or trust concept was actually wakaf, under Islamic law. So it's very interesting to understand it. Okay, so going back, we have discussed 1317. Now we are going back to 1316. In here it says, meskipun demikian adalah diperbolehkan untuk menanggung atau menjamin seorang pihak ketiga. Menanggung atau menjamin seorang pihak ketiga. Again, third party outside the agreement. Dengan menjanjikan bahwa orang ini akan berbuat sesuatu. Dengan tidak mengurangi tuntutan pembayaran ganti rugi terhadap siapa yang telah menanggung pihak ketiga itu atau yang telah berjanji. Untuk menyuruh pihak ketiga tersebut menguatkan sesuatu jika pihak ini menolak memenuhi perikatannya. So this is perjanjian jaminan, you can say. I put it in here as the warranty agreement, perjanjian jaminan, and I don't really have the exact wording for this. Perjanjian jaminan I differentiate it with the perjanjian penanggungan. Perjanjian penanggungan is different story, right? Must be distinguished from the guarantee agreement, perjanjian penanggungan. What is the difference? A warranty agreement is a standalone agreement, while a guarantee agreement is an accessory agreement. Perjanjian aksesoris kan, perjanjian ikutan. It means following another agreement called as the principal agreement. Principal agreement, perjanjian pokok, What is the principal agreement between you and the other party, between A and B? Let's say the principal agreement is the loan agreement. That's the principal agreement. To secure the loan, I will need to have a security, right? Perhaps through hak tanggungan, mortgage, or through fiducia, through pledge, gadai, and lain-lain. Those are accessories agreement actually, because those security agreements will not exist if there is no loan agreement, right? You understand this concept, right? So that's why it is called as an accessory, But the warranty agreement, perjanjian jaminan, is not considered as an accessory because it is a principal agreement. It is part of a principal agreement. In a guarantee, there is an agreement first between A and B, and then comes C, who promises to guarantee the fulfillment of the agreement. When, for example, B defaults, to its obligation under the principal agreement. C promises to A that he guarantees the fulfillment of the agreement by B. Yeah. C promises to A, the creditor, that C, guarantees the fulfillment of the agreement by B. So B is the debtor. B is the one who has to fulfill his obligation. C is third party, right? But C says to A, I will guarantee B obligation. Which means that if B is defaulting, A can chase C. Ya, this is the perjanjian penanggungan. But the perjanjian penanggungan of C will not happen if there is no agreement, principal agreement between A and B, right? But the warranty agreement is not like that. Yeah, warranty agreement is a standalone agreement, so it's not related to principal and accessory agreement. It's just an agreement. When someone guarantees that the third party will do something for the other party. That's why when we look in here, menjanjikan, ya, so menanggung atau menjamin seorang pihak ketiga dengan menjanjikan bahwa orang ini akan berbuat sesuatu. Orang ini kan pihak ketiga, ya. Dia menjamin si pihak ketiga ini akan berbuat sesuatu dengan tidak mengurangi tuntutan pembayaran ganti rugi terhadap siapa yang menanggung. Jadi kalau saya udah berani jamin, if I already guarantees this third party will do something, yeah, and this third party doesn't do it, yeah, the party receiving the benefit of my promise will have the right to file a claim against me to get some sort of compensation. Untuk menyuruh pihak ketiga tersebut menguatkan sesuatu. Jika pihak ini menolak. So if I guarantee that the third party will do something, but when the time comes that this third party doesn't want to do it, right? The other party receiving the benefit of my promise cannot sue the third party because it is a third party. It is outside the agreement. But the party getting the benefit of my promise or my warranty, the other party can file a claim against me and seek for some compensation because I will be considered as breaching my promises. So that is the warranty agreement. Yeah. Perhaps you won't really see it in practice. In practice, you can see its combination in a contract actually. Let's say that in one transaction, sale and purchase of shares, there will be a sale and purchase transactions for 5 companies. Yeah. And these 5 companies are actually managed by one party only, yeah, even though they are using so many names, yeah. They are using so many names, different directors, different shareholders, but actually they have been controlled by one party only. Yeah. So the total parties involved are actually 10 parties, for example. Yeah, but in this case, the agreement is made only between the controlling party, so one party only. So the other party, let's say that the controlling party is A, yeah, the controlling party is the seller, yeah, and B is the investor, yeah. So in this warranty agreement concept 1316 of ICC, when the A and B enters into a contract, of course the B will have to acquire all 10 companies, right? But the agreement is entered only with A, only one party. But even though this is controlling party, right? But only one party. Legally speaking, when you have a transaction with the 10 parties, you have to transact with the 10 parties altogether, right? You cannot just only use it one. unless, of course, this one party gets the proxy from everyone. So what happens in the contract between A and B, the B puts a clause there because he's an investor, right? B puts a clause that A guarantees that by the time of closing, which means that by the time of signing of AJB saham, akta jual beli saham, the 10 parties of the companies will have to be present before the notary to sign the AJB saham. That's the guarantee. And the warranty, you can say the warranty, because this is perjanjian jamin, this is not penanggungan. Yeah. So this is inserted in the sale and purchase agreement. It's not separate form. It's not when A is in default, then the other party will take over his obligation. No. That's penanggungan. Yeah. But this is perjanjian jaminan. So the A warrants that C, D, E, F, G, the 10 parties outside the agreement will come and will sign the AJB saham by the time of closing. Of course, there are conditions if the A cannot make all the other parties come at closing time. B can terminate the agreement and walk away. Yeah, so that is one of example. Yeah, one example of 1316. You will not see it very much actually. It is from time to time. Yeah, inserted in the contract. I have never seen it standalone agreement only with jaminan. Yeah, no. So it is like a variation in how you draft a contract. There are so many clauses, right? There are reps and warranties clauses, there are covenants clauses, there are declaration clauses, there are subject matter provisions and everything. And there is a warranty agreement also, a warranty clause in the contract. And then 1318, ya, jika seorang minta diperjanjikan suatu hal, maka dianggap bahwa itu adalah untuk ahli-ahli warisnya dan orang-orang yang memperoleh hak daripadanya. Kecuali jika dengan tegas ditetapkan atau dapat disimpulkan dari sifat perjanjian bahwa tidak demikian maksudnya. Ya, jadi dengan tegas ditetapkan that this cannot be assigned or this is not assignable, tidak bisa beralih, tidak bisa dialihkan, atau dapat disimpulkan dari sifat perjanjian by the character of an agreement. Ya. All rights and obligations arising from an agreement are inherited. Well, this is talking only about rights actually, ya. Maka dianggap bahwa itu adalah untuk ahli. Jika seorang diminta diperjanjikan suatu hal, it means my rights, right? I get some benefits of rights, ya. Maka dianggap bahwa itu my rights are also for the benefit for my heirs or assignees. Yeah, people gets the rights from me. But of course, in inheritance law, it is not only about rights, right? When someone dies, the rights and obligations are transferred, not only right. Yeah, what is nice. But what is not nice also transferred. That's in general for the heirs, inheritance law. But outside that, and this is talking about perjanjian, this can also mean that the agreement is still valid, right? Because it will be inherited. It will be passed through to the heirs. Yeah, to treaty, this is confusing. This is an agreement. Extends the personality of an agreement, yes. It's extending not only the parties but also the heirs of the parties. This is of the parties to the agreement. So there is a general title and also a special title ya. Let's say that you can say it alas hak umum ya sama alas hak khusus ya. Those who obtain the rights of this person can be divided into two groups ya. Of course, the heirs, ahli waris, right? But of course, if I have a joint asset with my wife, and then I buy something during the marriage, it will become the property also of my wife, right? Because there is a joint asset. Yeah, there is a joint asset in marriage. If my asset is separated with my wife, of course, it won't be like that. Yeah. So there is an exception on this. But the other part is the special rights, yeah. Alas hak khusus, yeah. Because when I own something, I can sell it out, right? I can assign my ownership to the other party. So my rights, of course, my assets will be decreased, yeah, from time to time, according to what my action will be in the future. And the other part that is also important in here is that the passing by heirs and person who acquire shall not occur if expressly established or inferred from the nature. This means that if you don't want this agreement to be assigned to heirs, you have to mention it specifically. Yeah. So this is not assignable. This will not be inherited by the heirs. This agreement will terminate by the time you die, for example. Yeah. By the time the company dies, for example. The person dies, for example, right? So, like in the proxy relationship, yeah, when you give a proxy or power of attorney to the other party, the proxy will terminate when the authorized person dies, right? The authorized person dies, then the proxy relationship will cease. So not every agreement will be passed to the heirs. Yeah, proxy relationship is not. So when the proxy dies, the proxy is ended. But the parties can also agree that specifically, yeah, that this agreement will not pass through to the assignees. Yeah. So when any one of us dies, or any company is dissolved, liquidated, and everything, the agreement will be terminated. Yeah, it cannot be continued anymore. We can agree on that. But there is also a character. Yeah. This example is labor agreement. Yeah? If I have a employee having a skill in, let's say, having a skill as lawyer, an employee having a skill as lawyer and having education as lawyer. Well, of course, when this employee dies, his heirs cannot just take over the employment agreement before, right? Because it's very specific. Yeah, employee, one person and the other person, one employee and the other employee are different, right? The different skill sets, different knowledges, different education, perhaps. Yeah, so it cannot be passed through, of course. The other example, like if you order a painting, well, it cannot be passed through to the heirs of the painter, right? Because every painter will have his characteristic of painting. Yeah, some do realist painting, some do abstract paintings, some do contemporary paintings, some do classical painting. So different painter, different style. Um, um, you cannot you cannot force that the hairs will take over everything, right? So it cannot be like that. So by its own character, the agreement cannot be passed through. Yeah. The agreement is not assignable. Yeah. By its character, by the character of the agreement. So then it's done. It's terminated. Yeah. When the employee dies, when the painter dies, of course nothing can be done. Yeah. You cannot expect the painting to be made by other person. Yeah, of course, because it's different. So that is the exception of 1318. But so you also understand with this clause that every agreement that you made, it will be passed through. By the way, Wendy is sick today, so how can I send the case study? Yeah? Who is willing to give me WhatsApp and then distribute the case study to the group? Yeah, perhaps later. Yeah, I need one person to do that. Okay, let me continue. We are almost at the end. The next is 1340. Yeah, 1340 is related to 1315 and 1317 actually. Yeah, the 1340 says suatu perjanjian hanya berlaku antara pihak-pihak yang membuat. Yeah. So the 1340 reaffirms personality principle of an agreement, as stated by Article 1315. Suatu perjanjian tidak dapat membawa rugi kepada pihak ketiga. So this is also an important principle, ya. When A and B enters into an agreement, the agreement between A and B cannot damage or cannot make a loss to the third party that is not related to that agreement between A and B. This is an important principle. Tak dapat pihak-pihak ketiga mendapat manfaat selain dalam hal yang diatur pasal 13-17. So, you cannot have burdens, okay? I don't see any exception on this, yeah? But cannot also get benefits of it except what has been regulated under 1317. So there is an exception for the benefits, yeah? So the 1317 that we discussed before. So basically everyone is free to make agreement or do whatever legal deeds he wants, and other can interfere or cannot interfere or hinder his actions. Yeah. So the 1340 reaffirms. So the 1340 actually is very related to the 1315. Now we move to 1341, ya. We are still in the akibat suatu perjanjian. Tentang akibat suatu perjanjian, the 1340 is there, and then the 1341. This is Actio Paulina, ya. This is a a famous clause, yeah. It's only one clause actually, but the principle is important. Let's see what it is. Actio Paulina stipulates that a creditor is given the right to apply for cancellation against unnecessary actions. Ini ya. Unnecessary actions done by his debtor, which is detrimental to him. Ya, artinya which damages him. Is given the right to apply for cancellation against any unnecessary actions which is detrimental to him. The word for annulment is interpreted thus so that the creditor does not have to file a lawsuit to cancel the deeds or agreements that have been done or made by his debtors, but he may also consider void all such deeds or agreement, which means they do not apply to. No, this is not correct. The creditor has to file a claim against the debtor. To request cancellation or apply for the cancellation of an agreement that has been held, it is necessary the one requesting the cancellation is a creditor of one of the parties. The agreement was detrimental to him. Such acts or agreements are not obligatory. The debtor and the are not obligatory, which means if you have to pay electricity bills, it is obligatory, right? You have to pay it. If you don't pay it, you will be a breach of contract. But the question is, are you obliged to sell your house to the third party? Maybe not, right? If you are default your loan to the bank and the bank takes over your house, it's obliged. You are obliged to give away your house and then let the bank sells it out because you are defaulting on your loan. Yeah. But when there is no loan, when there is no security put on your house, you're not obliged to sell it out, right? You may sell it out, but you are not obliged to sell it out. So in this third element, it is important such acts are not obligatory. If I may sell the house, it's not an obligatory, right? So I can do it or I don't want to do it. So it's an option. I want to do it, I can do it. I can do it, but I don't want to do it anyway. It's fine because it is not obligatory. But if it is not obligatory and I sell it anyway, and the sale of this property is damaging or detrimental to the creditor can file for a cancellation of that. So this 1341, okay, let's read it carefully. Meskipun demikian, tiap orang berpiutang boleh mengajukan batalnya segala perbuatan yang tidak diwajibkan. Batal segala perbuatan yang tidak diwajibkan. Jadi dia nggak bisa batalin yang diwajibkan, yang tidak diwajibkan, yang dilakukan oleh si berutang, the debtor, dengan nama apapun juga, yang merugikan orang-orang berpiutang. So detrimental to the creditor, damaging the creditor. Asal dibuktikan bahwa ketika perbuatan dilakukan, so this is must be proof. Asal dibuktikan must be proof. Bahwa ketika perbuatan dilakukan, baik si berutang maupun orang dengan atau untuk siapa si berutang itu berbuat. Jadi baik si berutang maupun orang yang enter agreement sama dia mengetahui bahwa perbuatan itu membawa akibat yang merugikan orang-orang berpiutang. Hak-hak yang diperoleh dengan itikat baik oleh orang-orang pihak ketiga atas barang-barang yang menjadi pokok perbuatan yang batal itu dilindungi. Okay, so this is the difference, right? If you are would like to walk away from your obligations and then you sell your property to the other parties, and this is the other party, let's say your family, your own family, your son, your daughter, your mother, your father, of course they know that you are trying to avoid the creditor taking away your property because of your loan, for example, that is defaulting. So this is the condition of 1341 paragraph, the first paragraph, right? Baik si berutang maupun orang dengan atau untuk siapa si berutang itu berbuat, Untuk siapa si berutang itu berbuat. Baik si berutang maupun orang dengan atau untuk siapa si berutang itu berbuat. Mengetahui bahwa perbuatan itu membawa akibat yang merugikan. Nah, but in contrast, of course, let's say, I'm not related with the seller, I'm interested with the house. Let's say that this guy wants to sell a house, but selling the house is just to avoid the bank, right? Because he is afraid that the bank will take over. But the house is free and clear. It's not mortgaged, for example. It's not under hak tanggungan. So he wants to sell the house. I'm I'm a good faith buyer. I don't know about his situation, that he's defaulting this bank. The bank would like to take over. I don't know about that, right? What I know is the house is free and clear, without mortgage, without hak tanggungan. I like the house. I have the money to buy, so I buy the house, right? So if I'm not related to this, I will be considered as a good faith buyer, ya. So that's why in here, hak-hak yang diperoleh dengan itikat baik oleh orang-orang pihak ketiga atas barang-barang yang menjadi pokok perbuatan yang batal itu dilindungi. Ya. That's why I'm protected, ya. So it means that even though the creditor tries to file a cancellation claim, if I prove that I'm a good faith buyer, my rights of the house will be protected. Untuk mengajukan hal batalnya perbuatan yang dilakukan dengan cuma-cuma oleh si berutang, cukuplah si berpiutang membuktikan bahwa si berutang pada waktu melakukan perbuatan tahu bahwa ia dengan berbuat demikian merugikan orang-orang yang mengutangkan padanya, tak peduli apakah orang yang menerima keuntungan juga mengetahuinya atau tidak. So, this is a general clause giving right to the creditor to cancel the action of the debtor. Yeah, but it's not easy, of course, to understand. It's not easy to know. But this clause, the same clause actually, is also stipulated in the bankruptcy law. Yeah, when the company goes bankrupt and it's taken over by the receiver, administrator, the receiver or administrator will have the right to file a cancellation of similar to this 1341, because it's quite common that the debtor will have to try to move or transfer its property to someone else but related to him, yeah, just to just so that these properties that are transferred will not become the bankrupt asset, ya, harta pailit, ya, because if these assets become bankrupt assets, of course it will be good for the benefit of the creditors. Now, why is it like this? Yeah, why is it the 1341 regulates something like that? Why? Because you have to revert again to the important provision under 1131 of ICC. Ya, in there it is mentioned, ya, 1131 KUH Perdata, ya, segala kebendaan si berutang, baik yang bergerak maupun yang tak bergerak, baik yang sudah ada maupun yang baru akan ada di kemudian hari, menjadi tanggungan untuk segala perikatan seseorang. The perikatan obligations, right? So all your assets, yeah, all the borrower assets, properties, movable or immovable, whether existing now or will exist later, will become the security of his obligations, right? So it means that this is why the 1341 exists, yeah. And that is why also the bankruptcy law exists, yeah. If you cannot do your obligations, I have the right under the law to ask for compensation, right? If you don't pay voluntarily the compensation that I am entitled to, I will chase your assets, I will chase your property, seize it and sell it, right? Jadi segala kebendaan si berutang becomes the security, actually. So the creditors of course need the property so that they will get compensation, right? They will get compensated. If the property is sold, the property is not belong to the debtors anymore, right? But the 1131 is very clear, segala kebendaan adalah tanggungan untuk segala perikatan seseorang. So that's why the law gives the opportunity to the creditor if it is these elements are fulfilled. Yeah, the agreement was detrimental. Yeah, the transfer is detrimental. It is not obligatory, right? And the debtor understand that when they do it, it will be damaging the creditor. Then the creditor is entitled to request for cancellation. And when it is cancelled, of course, it will return back the property to the debtor. And then the creditor will try to seize the asset, liquidate it, and get his compensation as his right under the law. Right? So those are the things for this session. So we have talked about the difference between obligations and agreement, right? And I also mentioned about the obligations rising from an agreement and obligations rising from the law, right? It's different thing. Yeah, it's different thing. And sometimes people are still confused, right? And types of obligation, well, there is obligations with timing, ya, perikatan dengan ketetapan waktu, obligations with threat of penalty, ya, dengan ancaman hukuman, conditional obligations, ya, perikatan bersyarat, right? And what else? Alternative obligation, perikatan mana suka, right? It's an alternative. You can choose either that you like. So, and then we talk about the open principle and consensus principle of an agreement. In here, we learn that the consensus principle is important, right? And then after that, almost all the time, all sessions after that will relate to the consensus principle, right? How to see when the agreement is considered to be valid, yeah, and when and the time, yeah, the time and location of the agreement to be bound, right? And the freedom of contract principle, of course, that the parties can make anything that they want, yeah, and anything that they want will bind the parties. Or in other words, the agreement is enforceable. Yeah, an agreement is enforceable. You can enforce an agreement even though the other party disregards your agreement with him. Yeah. We also learn about the conditions of the validity of an agreement. Yeah, when we talk about subjective requirements, objective requirements. Yeah, there is a consent between the parties. There is a capacity to enter into an agreement. There is a specified subject matter or the object of the agreement. There is also legal cause. Yeah, the agreement does not violate the law, public order, and decency, right? So those things we learn. We learn also about the consequence of having breached the subjective requirements. Yeah, it can be nullified, but it's not null and void, right? But when you breach the objective requirements of an agreement, the agreement will be null and void. Yeah, you don't need to ask for it. You don't need to ask for cancellation on it to the court. Yeah, it will be considered as null and void. You cannot enforce it.